last form of character evidence that we always talk about, again, remember we conceptually move purported character evidence about a witness off into a different place, because if we're not talking about the defendant before he's testified, a witness in a criminal case, or sometimes parties in a civil case, if we're not talking about these central characters, if we're merely talking about a witness, we want to let Article 6 govern that. But if we looking at character evidence, there's this last category as brought to us by 404B in the Rules of Evidence, that when we're trying to prove acts to prove something other than propensity. And really, if I want you to think about it like this. Now think about it relative to hearsay and character evidence. I always think about the definition of hearsay first. Hearsay is an out-of-court statement for the truth of the matter asserted. And that last part of the definition, for the truth of the matter asserted, is so central to our argument. Remember, someone's going to say objection hearsay, and they're going to embrace this definition, this 1, 2, 3, out-of-court statement, truth of the matter asserted. And we know now, after coming out of hearsay, we know the fight is with what I'm offering it for. As the proponent, am I offering it for truth of the matter asserted? So as proponent, just operating within the definition, before we get to all the non-hearsay and before we get to all the exceptions in 803 and 804 and residual in 807, before we get to all that, we know in the definition itself, in that 1, 2, 3, there's an argument there. And the principal argument, the argument if you're guessing at home, is this is not hearsay. You say hearsay, I say not hearsay, and specifically not offered for the truth of the matter asserted. That's not why I'm doing this. I'm not offering it for its truth. Part of your objection hearsay has to be why I'm offering it as the proponent, and I'm telling you it's not hearsay because I'm not offering it to prove the truth of what's in quotes, to prove the truth of this statement. And we learned about a bunch of things that maybe I am offering it for. Maybe I'm offering it for impeachment, to show that someone said 2 different things on 2 different days. I'm offering it not for the truth of what's in quotes, but instead the effect it had on whoever heard it, the effect on the listener. Maybe I'm offering it for notice, or circumstantial evidence of state of mind. I'm so hungry I could eat a horse. I'm not offering it for the truth of whether someone can in fact eat a horse. I'm offering it for circumstantial evidence that maybe that declarant is hungry, or maybe it's a legally operative act like an offer or a proposal or rescinding an offer and so forth. So we know, and we've embraced definitional arguments for the opponent and the proponent through hearsay, right? The opponent stands up, objection, and says this is hearsay, 1, 2, 3. The proponent responds and said this is not hearsay because you don't have 3. I'm not offering it for the truth of the matter asserted, instead for some other reason. Think of definitional character evidence that same way. We have an objection. It's objection improper character. You're not doing it the right way. If you're allowed to get into character evidence, this is not the right way, or this is just generally out under the prohibitions of 404A. So think about it. It has character evidence is labeling someone, telling a story from which we hope the jury infers some label for propensity, or that they acted in conformity therewith. Those terms mean the same thing. Propensity, or to show that a character in the play, criminal defendant, a victim, or sometimes party in a civil case, acted in conformity with some characteristic. So if the conformity therewith, or propensity, is central to this definition, it is part of the definition of character evidence, you already know, like truth of the matter asserted, how you can respond. You can respond by saying, nuh-uh. This isn't character evidence because I, the proponent, am not offering it for that part of the definition. I'm not offering it for propensity. It might look like character evidence. It might smell like character evidence. But in this instance, it's not character evidence because I, the proponent, am not presenting this evidence, not putting forward this evidence for propensity. That's part of the definition. And we know 404A generally excludes all evidence offered for propensity. So if you say, I'm not doing it for that purpose, it doesn't fall in the exclusion. Or more strictly, it doesn't even get classified as character evidence. It just looks like it. And 404B, for the prosecutors most likely, and with notice, gives us the other stuff. It's not offered for propensity, the stuff that looks like character evidence. It's offered for intent, for knowledge, to show motive, to show opportunity, plan, identity, absence of mistake. All those listed in the rule itself. So think about it. If you embrace as part of character evidence propensity, if you embrace that to show that someone acted in conformity therewith is part of it, then you can definitely think of the proponent's counterargument. You say objection character evidence. Character evidence is labeling someone, talking smack about someone, saying bad stuff about a character in the play for the purpose of propensity, for the purpose of showing that they acted in conformity therewith. Then the response from the proponent is going to be it's not for propensity. It's for one of these other reasons listed in the rule. And always remember 404B, of course, has a pretrial requirement. And look, here's what the instructions look like. Here's a federal instruction. It happens to be the Ninth Circuit, but all of them look like this. The instruction tells us you're going to consider evidence. You're going to consider other crimes, wrongs, or acts not charged, other bad stuff, maybe even about the defendant, as this rule typically plays out. But it's not offered for propensity. You're going to consider it for no other purpose. You're only to consider it for the reason offered, the reason proffered by the prosecution, intent, knowledge, motive, opportunity, and so forth, right? You can't consider this as evidence as guilt. You can't consider this for any other purpose, which means propensity. And never forget at the back end of this rule, I include a discussion of, I had a case once where it was a federal case with guns and drugs, and it was in a truck, and it turned out to be a car chase where he drove his truck all across the golf course and damaged a bunch of property, injured some people, a bunch of other crimes that I didn't get into. So when we found the car and eventually got the drugs and eventually got the guns, and subject the prosecution was just those federal gun and drug charges, I had a lot of other bad stuff to talk about. I had a lot of other property damage and injuries and other things that I didn't even have jurisdiction to charge in the federal system. So one of the things and one of the words you have to remember with 404B, you have to remember the term inextricably intertwined, or as some of the courts put it, part of telling the story of the case. In order for me to tell the story of drugs and guns being found in this particular car by this particular defendant on this day, I have to tell the story of what happened. I have to tell the story of the arrest, to tell the story of the chase. I have to tell the story of property damage and maybe even the injury, not because I'm saying it's some other crime, wrong, or act under 404B, but instead it's part of telling the story of this crime or wrong or act, even if I don't have jurisdiction to charge, or even if I've made the prosecutorial decision not to charge. So remember, inextricably intertwined, you always are allowed to tell the story of the case, or you're allowed to present facts and evidence that's inextricably intertwined in the case, even if they strictly are other crimes, wrongs, or acts. So what do you do to get around the notice requirement if you have this type of evidence? For me, I think you provide notice. You write a letter pre-trial, and you write a letter that you're going to present some other crimes, wrongs, or act. You're of the opinion that they are inextricably intertwined. You're of the opinion as the prosecutor that they're part of telling the story of this case. However, if defense counsel, upon receiving this letter, or a court in reviewing this matter later on in a motion in limine, disagree and decide that it is 404B evidence and that you need some other purpose other than propensity to introduce it, well, this is the notice, and this notice complies with the requirements of the rule under 404B. That way you're covered on notice, but you've made your argument clear that you don't think it's another crime, wrong, or act. So remember at the back end to think about character evidence just like you think about hearsay and definitional hearsay arguments. If the opponent stands up and says objection hearsay, embracing that hearsay as an out of court 1, statement 2, offered for the truth of the matter asserted 3, then you know the most popular response inside that definition from the proponent is, this is not hearsay, this is not offered for the truth of the matter asserted, it's offered for some other purpose, like those ones we've discussed, impeachment and state of mind and notice, and effect on the hearer or legally operative act. Think of character evidence the same way. Character evidence always has as part of it, that definition is part of it, and 404A is that it's offered in conformity therewith, to show that the person acted in conformity therewith. It's offered for propensity. So your response as the proponent, once you hear objection, improper character, your response as the proponent can be, this is not character evidence. It's not offered for propensity. I'm not offering this evidence to show that a character in the play acted in conformity with any characteristic. Instead, I'm offering it for some other purpose, those detailed in 404B: intent, knowledge, motive, opportunity, plan, identity, absence of mistake or accident, those types of arguments. And don't forget my word that's still on the screen, inextricably intertwined, to provide notice about a crime, about things that are intertwined with a crime, about part of telling the story. Even if you feel it's not an other crime, wrong, or act, you're still talking about this crime.